A government's role as employer is distinct from its role as sovereign. The standards used to assess whether government action violates the First Amendment vary depending on which role the government is acting in. In Shahar v. Bowers, we explore the standard applicable when the government acts as an employer. Law student Robin Shahar summered as a clerk with the Georgia Department of Law, an office under the state's Attorney General Michael Bowers. Bowers offered Shahar a job as a staff attorney starting upon graduation. In the interim, Shahar made plans to marry her partner, Francine Greenfield. Same-sex marriage wasn't legal in Georgia. In fact, Bowers' office had recently won the well-known case, Bowers v. Hardwick, in which the United States Supreme Court upheld a Georgia statute criminalizing sodomy. Consequently, Shahar knew her marriage wouldn't have any legal effect but intended to consider Greenfield her spiritual and practical spouse. On her formal application for the staff attorney position, Shahar listed Greenfield as her future spouse, and Shahar shared her wedding plans with department employees, some of whom were invited. When Bowers learned of the wedding, he withdrew Shahar's job offer. The withdrawal was based on concern that hiring an employee in a same-sex marriage would imply Bowers' approval, risking public confusion about the department's position on same-sex relations and undermining its ability to enforce Georgia law. Shahar filed suit against Bowers, alleging that the withdrawal violated, among other things, her First Amendment rights to freely exercise her religious beliefs and freely associate with an intimate partner. Both parties moved for summary judgment. The district court granted Bowers' motion and denied Shahar's. Shahar appealed to the 11th Circuit.